Hello guys, here I am, Atif Sattar, Advocate High Court and Law Tutor. In this video, we are gonna discuss about the evidence and its kinds. Normally in civil suits or in criminal trials, evidence is given to prove or disprove some facts. So basically the decision of the courts depends upon the evidence and its reliability. So first of all, we are going to discuss the definition of evidence, that what is the basic meaning of evidence and what is its definition. So you will find its definition in our Kanun Shahadat order, or you can say evidence law, in article 2, which states that any statement given in the court on oath is known as evidence. And basically evidence is of two types, and there are two definitions. First of all, any statement given in the court on oath, that is known as evidence, or any document produced for the inspection of the court, it is also evidence. So these are basic definitions of evidence, and you can have an idea from the definitions that basically evidence has two kinds. We can divide evidence, if we talk about its kinds, then we can divide it under two basic heads. First of all, oral evidence and documentary evidence. So what is oral evidence? When a person comes in the courtroom, goes in the courtroom and gives his testimony, that is known as oral evidence. And when a document is produced in the court as an evidence to prove its facts, or whatever is written in there, or agreement, or it can be anything written in that document, so that document is the proof of that thing. So basically there are two kinds of evidence, oral evidence and documentary evidence. If we further divide oral evidence, now I am coming towards the second head under which we can divide the evidence. It can be direct or it can be indirect. So basically there is a principle of universal principle of law, that principle that is known as principle of best evidence. To prove or to disprove some facts, whenever a person appears in the court, it is presumed that he will produce the best possible evidence to prove facts which he has alleged. If he do not produce the best possible evidence, then court presumes, that is provided under article 129G, that court will presume that that person has withheld, if that person has withheld some piece of evidence, that is because that was against him. So presumption of court will lie against that person. So there is a universal principle of best evidence, production of best evidence for the proving of facts. If best evidence is not produced, then presumption will lie that that evidence is withheld because that was against the party that has withheld it, that has not produced it before the court. So best evidence should be produced before the court. So if we talk about the direct evidence, so direct evidence is given by that person who has perceived through his own senses. We have five basic senses. We can see, we can smell, we can hear, we can taste, and we can touch something. So these are our five senses. If I perceive something, any occurrence through these senses, then I will appear in the court and give testimony, and that will be direct evidence, because I have perceived. If I have seen the occurrence happening, I have seen someone firing at some person that was killed, that was murdered, then I am the eyewitness of that. I will appear in the court. Best evidence will be that I appear in the court because I have seen that occurrence. If I heard the noise of firing, I will appear in the court and I will give evidence that I heard the noise of firing. Similarly, if I smelled the gunpowder, then I will appear in the court and I will give evidence that I have smelled gunpowder while passing thereby, while passing from that street or wherever. If I sustained a gunshot injury, then I will appear in the court as an injured, and injured witness is the best witness in the criminal proceedings. So basically evidence should be direct. We have seen in article 71 Kanun Shahadat order that oral evidence must be direct. It should not be hearsay. In simple words, I will explain hearsay evidence. Hearsay evidence is someone tells me that someone other told him about an occurrence and he is telling me, and now I am appearing in the court to give evidence, so this will be hearsay evidence. Someone told him and he told me, so this is the hearsay evidence and it is inadmissible. So there are few exceptions to hearsay evidence. For example, if someone is killed at a place where only there are two persons, one person kills another, there is no eyewitness of the occurrence, so how will you prove that A has killed B through direct evidence? When there will be no direct evidence, court has lawmakers have showed wisdom that case can be proved upon indirect evidence as well as circumstantial evidence. Circumstances, if we get a CCTV footage of the person who came at that place and after killing another person he went back, if we get the video, then we can presume from that video, we can deduce from that video that this could be the suspect who went there and who went back after the murder. So there are exceptions to the hearsay evidence. Now I will tell you about the exceptions one by one, that in which circumstances indirect evidence is also admissible. So first of all, it is res gestae. After that we will come to article 30 to 36 Kanun-e Shahadat order, and 37 to 43 in which admissions and confessions are given. Normally a person admits his guilt or admits his whatever you can say, the claim of other party can admit outside the court in front of another person, then that person can appear in the court and this will be indirect evidence. If person confesses his guilt to some other person and that person appears in the court and gives evidence, so that is also admissible piece of evidence. Now we can say another third is the dying declaration provided under article 46(1) Kanun-e Shahadat order, our evidence law. In dying declaration, the person who is about to die gives a statement to a doctor. It can be given to a doctor, to a private person or to a police officer, that about with reference to the injuries and about the person who inflicted those injuries upon him, about which he is believing that because of them he is about to die. So he will give him dying declaration about the person who inflicted those injuries. So that dying declaration is an admissible piece of evidence if that police officer or that doctor in front of whom the dying declaration is made appears in the court and gives evidence. So this is also indirect evidence, but it is admissible. It is provided under exceptions to the hearsay. Statements given in previous judicial proceedings are also admissible, despite they are indirect evidence, so they are also admissible. Similarly, the opinion of experts. If an expert appears before the court, he has not seen the occurrence happening, he cannot say that I saw that the bullet entered from front side of the chest and it exited from the back side. But through his expert knowledge, through his professional knowledge, through his experience, he can analyze from the types of the wounds and from their margins that this wound has inverted margins, so this is entry wound, and that wound has everted margins, so this is exit wound. So the opinion of expert is also an indirect piece of evidence, but it is admissible in courts. It is admissible as an evidence in the courts. It is also an exception to the hearsay evidence. So this was our video on the evidence and its kinds. Hope so you would like it. If you have any question or any comment, you can comment on the comment section. I will answer to them. I will answer to your queries. Thank you very much.